Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello and welcome to another in our series of podcasts, which are focused on cases, developments and issues impacting international commercial and investment arbitration. My name is Declan Gallivan. I'm a Senior Commercial Disputes Associate in the London office of KNOETZL. I have a varied disputes practice with a particular focus on international commercial arbitration. This podcast today is titled The View from Vienna. Austria, as many of you will know, is a reliable and arbitration-friendly jurisdiction, which continues to grow in popularity. In a moment, I'll introduce an exciting guest speaker to talk about an important arbitration-related judgment of the Austrian Supreme Court. But before we dive in, a few housekeeping points. First, this presentation is limited in scope as appropriate for a general audience and applicable time constraints. Second, this presentation is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of specific facts of a given case. Finally, all speakers appear in their personal capacities, and any opinions or views offered are those of the speaker alone and do not necessarily reflect the opinions or views of KNOETZL or any other entity or individual. Right, let's get back to it. I'm joined today by Florian Haugeneder, a partner in and co-founder of the Austrian law firm KNOETZL. Florian has extensive experience as counsel and arbitrator under the rules of the major arbitral institutions, as well as in international and domestic ad hoc arbitration. Florian, thanks for agreeing to participate. Please tell our listeners more about you and your practice.
Hello, I'm Florian Haugeneder. I'm partner at KNOETZL. I'm practicing both as arbitrator and counsel, and the clear focus of my practice is energy as well as construction and engineering. Energy disputes in particular have been on the rise in the recent years. The reasons for that was not only the invasion of Russia, of Ukraine, and the interruption of the gas supply, but also the run to renewable energy, which meant limited capacity, limited transmission networks, and a run to the available limited projects. So we have seen a steady rise of energy and energy-related arbitrations in the past years. And that rise has dramatically increased with the interruption of gas supply in Western Europe due to the invasion or as a consequence of the invasion of Ukraine by Russia.
Thank you, Florian. Very interesting. So we've decided today to focus on a landmark Austrian decision concerning an arbitration seated in Belarus. Please, could you tell us a bit about the facts or background to the decision? How did this case we're talking about arrive at the Austrian Supreme Court?
Yes. So the case has an interesting factual setting, and it predates the present energy crisis. But as I will later discuss, it probably has consequences in the present situation. The basic facts were as follows. There was an Austrian party that entered into an arbitration agreement with the party from Belarus. The party from Belarus was state-controlled. The party from Austria initiated arbitration before the Chamber of Commerce and Industry in Belarus, and it prevailed against the party from Belarus. And the arbitral tribunal awarded a sum of money to the Austrian company. The party from Belarus complied with the award and actually paid the awarded sum, but then initiated setting aside proceedings. And in these setting aside proceedings, the courts in Belarus held that the arbitrators had misspelled the name of one of the arbitrators. That spelling error was corrected during the proceedings, but that correction was not in accordance with the applicable formal rules. And that was apparently the reason why the award was set aside. Now, the Austrian party, in despair, they write in their submissions, initiated another arbitration proceeding claiming the same amount again. But this time, the party from Belarus brought a counterclaim and was reclaiming the money that was already paid to the Austrian party. And this time, the party from Belarus prevailed and got the repayment awarded by the second tribunal. And with that award, the party from Belarus went to Austria to enforce that award against the Austrian party. And the Court of First Instance initially granted the enforcement of that award. That decision was overturned by the second instance, and ultimately the Supreme Court had to decide on this matter. And the Supreme Court upheld the decision of the second instance, so it held that the award was not immediately enforceable. And the reason for that was, it said, the enforcement of awards in Austria is governed by the New York Convention, which is directly applicable. So there's no Austrian statute governing enforcements, and the courts regularly apply the convention. And according to Article 5.1e of the New York Convention, the setting aside of an award in the country of the seat of the arbitration is a ground for refusing recognition and enforcement. But importantly, the Supreme Court held that the setting aside proceedings must comply with Austrian Ordre Public, because otherwise arbitration and the protection of rights by way of arbitration could be frustrated by the courts of the seat. And in this case, the court held that if the sole reason for setting aside the award was a spelling error in the name of an arbitrator, which was even corrected, then this is clearly arbitrary and not in line with Austrian Ordre Public, with the consequence that the first arbitration award is still valid, and therefore the second arbitration award cannot be enforced in Austria.
Thank you, Florian. That's a very interesting set of facts. And that appears to be a very robust pro-arbitration stance from the Austrian Supreme Court. Obviously, this is one decision involving Belarus, but this is a topical decision which could have wider consequences, couldn't it?
Absolutely. As you say, the approach of the Austrian Supreme Court is robustly pro-arbitration, and that stance could have a wider implication in the present scenario. Presently, we're seeing a number of arbitrations, especially in the energy sector, especially involving parties from Russia, where we see a sort of a power struggle between the Russian courts and institutions on the one hand and parties from Europe on the other, where arbitral tribunals on the one hand have to deal with court decisions which hold that arbitration agreements with unfriendly institutions from unfriendly states are no longer valid, or decrees interfering with contracts, especially in the energy sector, holding that parts of these contracts are no longer enforceable against Russian parties. And if we transpose the rationale of the Supreme Court, then this is a clear indication that the Austrian Supreme Court is not going to take a naive stance regarding such court decisions. Of course, looking at the relevant facts all the time. So we cannot make any general statements about the present situation. But the Supreme Court was clear in that it would not stay on the surface of legal decisions that are incompatible with the Austrian and international public order, but would look at the actual facts. And in this case, the Supreme Court was clear in saying that a spelling or error or the like is not compatible with the Ordre Public.
Yes, thank you. I agree. It's a pretty stark set of facts. This all boiled down to a spelling mistake at the end of the day. And you can imagine there might be some cases in the sort of grayer area, which are quite interesting, but let's see. Thank you, Florian. What has the reaction been to the decision in Austria?
There were two sorts of reactions. One from the wider arbitral community and arbitral institutions who were broadly in favor of the stance taken by the Supreme Court. But especially in academic circles, there was some, say, muted criticisms because they say that effectively the setting aside of an award under the New York Convention is a ground for refusing recognition and enforcement. And the New York Convention doesn't provide for a review of the setting aside decision. So essentially, these commentators are saying that the court went beyond the scope of the New York Convention. And that is, of course, true to the extent that there shouldn't be a general review of all setting aside decisions by the enforcement court, because ultimately this would lead to a situation where the setting aside has no effect on the recognition and enforcement anymore. However, I agree with the Austrian Supreme Court that there must be a limit to that. Because otherwise the approach would be naive in the sense that countries where the rule of law prevails would abide by their obligations, and other countries not complying with the rule of law would basically have a free hand to comply with arbitral awards or not comply with arbitral awards and use their institutions to enforce their interests. So the Austrian Supreme Court was clear in saying that they're not going to be naive and that they would look at the concrete facts of the case and to see where to draw the line. The Austrian Supreme Court is traditionally very reluctant to hold that something is against the Austrian ordre public. So rarely ever a decision is held to be contrary to the Austrian ordre public, even if it is contrary to Austrian mandatory law. The ordre public is really limited to violations of basic notions of justice and fairness, and only really egregious breaches will be held as contrary to the Austrian ordre public. But in the present case, the spelling error of an arbitrator that was even corrected, that was so evidently against any notions of fairness and ordre public that I think the Austrian Supreme Court was right in drawing a line.
Thanks very much. I agree. That sounds sensible. Before we end, Florian, we're currently recording this podcast virtually, and so much of what we do these days is online and virtual. I know the Austrian Supreme Court also issued a judgment concerning virtual hearings. Can you tell us briefly about that decision, please?
Yes, that decision was taken in the context of the COVID pandemic, as you can imagine. And the facts of this case were two parties, one from Austria, one from the US, and the party from the US requested that there is a personal hearing. And the arbitral tribunal nevertheless ruled that in view of the pandemic, there should be an online hearing. And ultimately, the hearing was held online. And then the party from the US challenged the arbitrators because they said this indicated an unfavorable predisposition of the arbitrators against the party from the US. And here again, the Austrian Supreme Court was robustly pro-arbitration in holding that the arbitral tribunal was justified or had the power to order an online hearing even against the objection of one party. And in coming to that decision, the Supreme Court said that it was widely recognized also in court proceedings and also in criminal proceedings that online mechanisms and online hearings could be used, and also said that this was recognized to be in accordance with due process and human rights. And it then went on to say that in the particular circumstances, and in particular having in mind that there was the COVID pandemic, which prevented personal hearings, the arbitration tribunal had to weigh between effectively granting the right to pursue a claim in arbitration within reasonable time, and the right to be heard and to present one's case orally. And in weighing these circumstances, the arbitration tribunal was right in opting in favor of an online hearing. And then there was also an argument about the possibility of influencing the witness in an online setting. And here the Supreme Court said that the possibility of influencing a witness could also not be completely excluded in personal hearings. So the situation was not fundamentally different, and that there were technical means of preventing such influences on the witness. And so ultimately, the Supreme Court rejected the challenge. And that was, to my knowledge, the first decision of any Supreme Court in the traditional arbitration jurisdictions where the court was so firmly in favor of online hearings. And after this decision, my impression was that this approach was widely accepted by arbitral institutions, but also by other courts.
Great, thank you so much. Thank you for your time, Florian. Thank you everyone for listening. We hope you enjoyed the podcast today. Thank you.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.